All right. Hello, everybody. And thank you so much for joining us, both to folks in the room and those of you who are joining us online. I'm Alexandra Reeve-Givens, CEO of the Center for Democracy and Technology. And for those of you who don't know us, we are a civil rights and civil liberties organization that focuses on protecting human rights and democratic values in the digital age. One big area of our work is on privacy, which is why we're here today to talk about the latest rulemaking from HHS's Office of Civil Rights on protecting reproductive health privacy, and in particular, patients' medical information. We're here with Director Melanie Fontes-Rainer, who leads that office. And after our fireside chat, which will last for about 20 minutes, we're going to transition over to a panel of experts who will talk about the rule and its impact for patients and for providers. It's a wonderful group. It'll be moderated by my colleague, Andy Crawford, who is our senior counsel on our privacy and data team. We have Aaron McKay, who's managing director for health justice at the National Partnership for Women and Families, Alice Leiter, who is a counsel at Manat Health, and Lisa Myers, who is a senior Washington counsel at the American Medical Association. But first of all, Director Fontes-Rainer, we're so happy to have you here, and would love, just to kick off a conversation about the rule. But before we even go into that, not everybody is familiar with your office, so I'd love for you to talk a little bit about that and the work that you do.
Yeah, so thanks for the opportunity and thanks for the question. The Office for Civil Rights is a national facing organization at the U.S. Department of Health and Human Services. What folks don't totally understand is that most federal agencies have a civil rights office. So ours is for things that are funded and out of the U.S. Department of Health and Human Services. We're the only civil rights office that not only does civil rights, which is quite a big mandate, right? Civil rights of age, race, disability, sex-based discrimination, among other things. We also are in charge of HIPAA for the department. And so a lot of organizations have two separate offices do those. We at the Office for Civil Rights have one organization that does those. We have offices in 11 cities across the country. So there might be a physical location no matter where you are in the country, but we also have an office here in Washington, D.C., and we have staff all around the country. And so our mission is to make sure that you can access healthcare free from discrimination. Our mission is also to ensure that your protected health information, your data, your security, your health records are secure and they're kept private. And those are our mandates under HIPAA, which we take that charge very seriously and is quite, if you think about all of our work, a large bucket of our work is HIPAA related. So whether it's cybersecurity or it's the privacy rule or it's breach notification. So it's really important work and we appreciate the opportunity to be here with you today.
Wonderful. Well, as I mentioned, privacy is core to CDT's mission. We ourselves were very involved in filing comments for the rule, and more generally thinking about what reproductive privacy looks like right now in the 21st century and after the Dobbs decision. Would love to hear kind of your perspective on the rule that you've just issued, and in particular, the value that it has for the patient-doctor relationship and how we keep trust in the ability for people to have those conversations and know that that information will be kept private.
Yeah, I mean, so I think, we all think first off, there's a lot of misinformation about what HIPAA does and does not cover. Just fundamentally, I think when you talk to people, they say, oh, well, it's my medical record, HIPAA. And you and I are both lawyers, right, who work in this space, we know that that's not always the case. But I think what this rule does is it really tries to protect even that notion of what privacy is with respect to our providers. So we know that if you don't trust your doctor, if you don't trust your provider, your nurse practitioner, whoever you're seeking care from, that can impact the kinds of things you're telling your provider, that can impact your visits and the relationship you have with your provider. And ultimately that can have an impact on your health outcomes. We know with Dobbs that we know that protected health information, people's medical records, is more likely to be used for investigatory purposes to understand what kind of healthcare people are receiving in the first instance in a way that I don't know many people would think. I'm going to my doctor, somebody might be looking at my records to determine if I had a particular type of exam, if I had a particular pregnancy test, if I had a particular reproductive health care service, right? And so we're trying to foster that protection. That protection is certainly a major tenet of HIPAA itself. And in fact, when they created HIPAA, right, Congress literally said to HHS, go create this privacy standard. It's important. We know it's important for care coordination. We know it's important for health outcomes, but also making sure that the department had that ability to do so. And so, post Dobbs, we know that there's a lot of distrust in this space, and frankly, with doctors too, right? I've had doctors literally tell me, I'm worried about my patient's records we're considering doing X or not even keeping things in the record because they're worried about how these records might be used in their state, outside of their state, and overall. And I just think these are things that, look, your healthcare is important. Your healthcare matters. You shouldn't also have to go to your doctor's office worrying what is the paper trail of my records and how's that going to be used against me or my provider in the first instance. And so this was really meant to reinstill that medical trust and to make sure people don't feel so scared that they can't go seek that healthcare that they might need in the first instance.
So digging a little more into the weeds, can you actually just walk through what the new rule does and kind of what protections you're offering for people?
Yeah, so the new rule updates the HIPAA privacy rule. So currently, I think as most folks know, but I'll just quick snippet. Currently under HIPAA, there are permissions to use with respect to use and disclosure of protected health information. We put out guidance right after Dobbs just to really clarify that for folks. So folks understood HIPAA itself doesn't require use and disclosure of data, only in 2 instances for the HIPAA right of access and when there's a breach. So we put that out, and what we got back from a lot of individuals, patients, providers, organization was this isn't enough. And we know that there are many instances, even under the current state of the HIPAA privacy, where people are just handing over data, and it might be affecting health outcomes, patient-provider relationships, et cetera. So we went a step further, and this rule actually says, okay, we're actually going to prohibit use and disclosure of protected health information when it's by law enforcement for the purposes of an administrative, civil, or criminal investigation, or to impose liability on that individual or that provider for the mere act of seeking lawful reproductive health care, which can be abortion. And so we went a step further to say these aren't just permissions, we're actually prohibiting it if it's for one of these prohibited purposes, to really tighten that up and to empower providers. Because again, there are providers out there who are very sophisticated in this space. They've been in this the long game. I mean, a lot of abortion providers, they know that they don't have to hand over certain things or that they have some discretion in when they do. But I think what Dobbs did was they ripped that open to not just abortion providers. And it said to every single provider that's in your chain of healthcare, whether it's your dentist or you go to an emergency room and you have a pregnancy test because you're having some sort of surgery, have a medical record that might confirm whether or not you're pregnant. And that is valuable information to folks who want to identify people who are getting healthcare. And so I think this empowers providers in that respect. It gives patients that peace of mind and clarity so that they know that their providers are empowered and they know that that information will be private. And it also allows for continued actual law enforcement functions. I mean, a lot of people have said to me, doesn't this mean that this is infringing on law enforcement? I mean, I run a law enforcement, like OCR is a law enforcement agency. As long as I'm not using this information for a prohibited purpose, I'm still able to get this information if I go through the process the rule lays out. And I think that's an important step to flag.
You talked about a couple kind of important examples so people understand how this rule will act in practice. Another one that I think is top of mind for a lot of people is the information that pharmacies hold.
Mm-hmm.
So in December of last year, we saw a letter from Congress that came to HHS, followed by a whole bunch of newspaper reporting about how pharmacy chains were actually handing over people's medical records or patient information without getting a warrant first. Would love to hear your take on how this rule applies to that pattern.
Yeah, and I'm sure you and your team have read, as have others, this rule. Hopefully everyone's read it by now, but
page for page, over 200 pages, people.
But seriously, you should read it. But no, so I will say our actual preamble talks about this letter, right, that was sent to HHS. We've had conversations with Senator Wyden and his team, as well as other senators on this letter. Yes, it's important to show people, because again, people think my information is protected by HIPAA. I'm safe. What they don't understand is that under the current state of the rule, before this rule goes into effect, that's not always the case. And even in instances where folks can push back, look, you're on unequal footing when you are at the front desk or you are at a pharmacy counter and you are on the other side of someone in uniform or someone holding a warrant. That's just a fact. That's not something I made up. That's just like life, right? And what we also don't think about, like the investigation itself was on large pharmacies, right? Like very large pharmacies across the country. So not a small provider, not a small, dental office somewhere where it's just the front desk person running these things. These organizations really need to be thinking about what HIPAA does and does not require. And also with respect to this new rule, how they're going to be compliant. And so, with respect to the warrant requirement, we've talked to Senator Wyden, and I know he, likes parts of this rule. And so we're excited to work with him on opportunities he thinks more about HIPAA overall and how to make this stronger overall for patients. But it is something we're aware of. And I think it is just one of the ways in which people show this rule might be helpful, right? Because again, these pharmacies were just handing over information. They were not required to. Now, I know like it's not my investigation, so I really can't comment on what they did or did not receive in this investigation. But we also know how HIPAA works. And so I think this is a really important step because they will be empowered now to say, no, I can't give you this information unless they know it's not for one of these prohibited purposes and there's some alternative piece of the HIPAA privacy rule that they're able to get the information from, which I think is important.
So part of the benefit really is clarity then, that it's not
Absolutely.
just to their discretion, do they comply or not comply? There's now a rule that actually guides them on that.
Absolutely. And in fact, the preamble itself, we tried to make as clear as possible so that providers really feel empowered to do that, right? Because again, these are giant pharmacies, but HIPAA applies to everybody. So small, medium, large, extra large, like and so forth. And so we know at one end of the spectrum, sorry, I'm not using my microphone, but at one end of the spectrum, right, you might have a general counsel, you might have a privacy officer, you may have a firm you use for this stuff. And at the other end, it might literally all be the same person who's answering phones that's also required to say whether or not someone's records are going to go out, right? And I think we're trying to do a lot of information sharing, but also making sure that organizations, large partners, they feel empowered to help share this information because we're trying to be as clear as possible to help protect people's privacies.
So now let's talk a little bit about the rulemaking process. Full disclosure, CDT filed comments. A number of the groups and privacy advocates that we work with also filed comments. We were joined by many others. You got over 30,000 submissions. Can you talk a little bit about some of the trends you saw in the comments, how the agency responded to them, and in particular, if there were changes from the proposed rule to the final rule as a result of the comment process?
Yeah. So of course, we received 30,000 comments, which is actually quite a lot for a HIPAA rule, right? Because HIPAA comments aren't typically short or simple. And so we did receive a lot of comments and we went through all of those comments. I think both on the front end, on the back of the end of this rule, we did a lot of listening sessions. So I personally have been to almost all 20 of states that have banned or restricted abortion care. And those conversations were largely directed by President Biden's executive order. And those conversations were about compliance. How do we follow the law? What does this mean for us? And in a lot of those conversations, we heard things like, I've had doctors in certain states tell me, if my patients get pregnant and they want to stay pregnant and they're high risk, if I tell them if I were their loved one, I would tell them to leave the state. And, that should be shocking to many people, right? A doctor telling their patient that they don't think they're safe in a particular state. Now, look, this rule doesn't change that. Unfortunately, that means, we don't actually touch access in general, but this rule would allow that doctor to help that patient navigate the healthcare system and to protect their privacy. We've got a lot of comments from organizations, providers, patients, a lot of lawyer organizations and states. And so I think we were pretty responsive to the comments overall. And I think, we'll look forward to working on the next step of this, which is like education, trying to do outreach with respect to those organizations. The rule largely tracks the proposed, so not a ton of changes. I would say the biggest change, which I think folks are aware of, is the presumption, which I'm happy to talk about now or later in the conversation, but it was one of the changes.
Yeah, I would actually love for you to talk a little bit about that now.
So we did get a lot of comments that were largely from provider organizations and providers so under the rule construct, if it's lawful care, it is allowed to be protected under this rule. And what we got a lot of comments was, well, if the patient is like, if I'm in a banned abortion state and my patient leaves my state to go get healthcare somewhere else, how am I going to know for certain that the care was lawful, right? I didn't provide the care. My patient traveled. I can assume, right? I assume that my patient went to a provider and got lawful care, but I didn't provide that care. So the presumption itself would allow that individual provider to presume the care was lawful unless they had actual knowledge or some other reason to think that it wasn't lawful in the first instance. The presumption itself can be overcome in those instances where it doesn't do those things, but that was a pretty strong comment we got from a lot of providers, was to say, I'm not a lawyer, right? And we're asking doctors to do so much these days, right? Doctors are not lawyers, lawyers are. And so could you please make this clear? And we did that through the final rule.
One of the big questions, I think, is going to be implementation. So having patients and patient advocates know about this rule and kind of know what it means for their own privacy. And then, of course, the provider compliance piece of this too. Can you talk a little bit about, number one, how you're raising awareness of it? And number two, what you think compliance looks like? Like what steps a provider is going to have to take now as they get ready for the rule to go into effect?
Yeah, so the rule itself takes effect in June of 2024. However, we won't start enforcing it until December of 2024, which means folks have time to get ready. It is an update to the existing HIPAA privacy rules, so much of that is staying in place. So there isn't that much more to do. And I would argue, given that it was a discretion with respect to the permissions in the first instance, it's just solidifying that in a way. But things like the notice of patient privacy, those will have to be updated, and we have a timeline for that in the rule. Making sure that the trainings happen so folks understand what is and isn't required under the rule. And so our office is a small organization. However, again, we try to work with organizations like yours or some of the major medical associations or insurance associations and others to try to educate as much as possible because frankly, that's the best we can do, right? I don't have a budget to do commercial. I mean, I'm not CMS, right? I don't control a sixth of the GDP. So, I think that's what I think it is. But so we try to do as much outreach and education as possible. We have 2 videos up on our website right now, one in English, one in Spanish. They'll be dubbed in different languages coming soon as that's done. A fact sheet, a press release. We'll think about more webinars. So we're actually planning regional webinars in each of our regions, both this and some of the other rules we have coming out in the last 2 weeks. So I think we're trying to do as much as possible, but also if you're watching this and you think, oh, it would be really helpful to have OCR come to my regional event, or it might be helpful for the OCR do a specific fact sheet or something, like let us know. We're open and willing if we can.
Watching the press conference last week where Secretary Becerra talked about this rule and you were up on stage shortly after him, one of the things that he really seemed to be focused on is patients knowing their own rights and saying, if people are violating this, we want to know about it. So can you talk a little bit about what this looks like from the patient perspective? Number one, raising awareness, but number two, if somebody thinks their information is being shared inappropriately, what do they do?
Yeah, so it's a good flag, and of course, the secretary is so wonderful for giving privacy this platform, which truly we applaud. I think a couple of things. So OCR on a regular basis does videos, newsletters, technical assistance guidance, has enforcement actions. I think if you want to sign up for our website, that's one way to track those things. So you can go to hhs.gov/OCR. That's our main page. It has information on HIPAA. It has places you can sign up for our listservs. I think that's a good information channel. Now, do I think like my mom from Phoenix is going to sign up for the OCR HIPAA? Maybe because I'm her daughter, but probably not. And so I think if you think that your privacy rights, your HIPAA rights have been violated, you can file a complaint with OCR. Again, hhs.gov/OCR. It tells you how to file a complaint. You can go through that process. If you're not sure if you should file a complaint or like you're from an organization, reaching out to us or one of our regional offices is always a possibility. But generally speaking, you can file a complaint with OCR, and there are a lot of actual consumer-facing resources on our website. And we're trying to do a lot more of those. So we just put up 2 YouTube videos, for example, where we tried to distill this rule as simple as possible to try to help drive information and empower consumers in the first instance.
That's great. The final question I want to end with is kind of just situating this in the broader conversation around privacy, and in particular reproductive privacy, and kind of the light of conversations where our nation is right now. We've talked a little bit about the limits of HIPAA, right? There are the powers of HIPAA, and then there are the limits of HIPAA. And I would say CDT as a privacy organization is very focused on some of those limitations and what we do for non-HIPAA covered entities, non-HIPAA covered data, how we strengthen those protections, for example, through privacy legislation, through strong enforcement by the FTC to make sure that people are living up to their privacy obligations. You're the cop on the beat for the HIPAA covered conversation. And some of the other work that you've done, is, for example, reminding medical providers that if their website is tracking information about their visitors to their site, that may well be protected health information. So I'd love just to hear a little bit about kind of your broader efforts beyond this rule and anything else you'd like to share.
Yeah, so you gave some good flags there, and I can extrapolate in those a bit more. So, we cover some of the things on your phone, but most of the things on your phone are not covered by us, which again, that's I think a myth of many people with HIPAA. So we actually put out guidance. It's been 2 years now. We put out guidance, FTC put out guidance to say, hey, you are going to be your best privacy advocate in this space. frankly, like I care a lot about your privacy, but your privacy really is in your own hands. And so being very diligent about what are you downloading to your phone? What are you storing on your phone? Don't store protected health information on your phone. Think twice about free applications you might use, right? They might be selling or using your data in a way that might not be up to your choosing or really protect your privacy in the first instance. Things like that we think are super important. We put out telehealth guidance with respect to phones, right? Phones can be a really helpful option, both to meet civil rights obligations for persons who say can't utilize certain technologies, or maybe live in certain communities where they don't have access to broadband internet, things like that. Those are ways in which you can receive healthcare. And they might also be helpful in protecting your privacy. And then I think you talked a little bit about web tracking. We know we put out guidance now over 2 years ago. We just updated it in September of this past September, the past year. Did I get that right? No, March, excuse me, March. March of this past year, we just updated our own guidance, but this guidance is with respect to web tracking platforms like Meta, like Google Pixel, because we know a lot of hospital systems are using these. They're not bad to use. It's just you have to make sure you're into a business associate agreement to protect that information if there is an impermissible use or disclosure or breach. And actually, we've seen cases like that pop up as of last week. And so I think it's really important to remind folks that that guidance is extension of our HIPAA rule. We were trying to be responsive to the types of questions we were on it. Obviously, we're getting sued on that, so I can't say really that much, but I think it is a good flag so that folks have visibility that these are other ways in which even your own providers might be trying to improve your health experience, but maybe using platforms that otherwise may expose your using data. And then I think overall, we work really closely with the FTC. We have regular meetings with them. We work really closely with our partners across the department, FDA, ONC, and others, and making sure that as Congress thinks about this issue, and I know that there's some bipartisan support in the space, that we really are supportive and want to be at the table and making sure that we're helping as much as we can.
That's great. And even though this rule, of course, is focused on reproductive health information, the broader issues that you're talking about really do apply to medical conditions across the board and the overall need to make sure that there are strong protections in place for that type of sensitive information.
Yeah, absolutely. Yes, absolutely.
All right. Well, again, thank you, Director Montezurno. Thank you so much for joining us today. And we're going to transition now over to our panel. That involves pulling up some more chairs. So bear with us for a moment as we do that. Thank you.
Well, hi, everybody. We're transitioning to the panel portion. For folks who don't know me, I'm Andrew Crawford. I'm a senior policy counsel here at CDT. I'm on our privacy and data team, and I help lead our health privacy work. We just had a fantastic fireside conversation, but now we've got more experts to take a slightly deeper dive into the rule. We've got folks from many different constituencies represented. So we're going to ask this panel of experts some really fun questions. But I should introduce them, right? So first off, we've got Lisa Myers. Lisa is a senior Washington counsel at the American Medical Association's Division of Legislative Counsel. She handles health data privacy and security matters, including HIPAA. Prior to joining AMA, Lisa worked at HHS's Office of Civil Rights, contributing to several recently published rules on privacy and health information. Lisa also served in the Office of General Counsel for a major health plan for 10 years, overseeing implementation of the first iteration of HIPAA. Next, we've got Erin McKay. Erin is the Managing Director of Health Justice at the National Partnership for Women and Families. She supports a portfolio of health justice projects focused on system transformation, health equity, and maternal health. Erin's a respected patient and consumer advocate with expertise in health system transformation, patient engagement, and digital health. And last but not least, we have Alice Leiter, counsel at Manat Health. Alice focuses on health information privacy, new data use cases, and data policy and health regulatory issues. Before joining Manat, Alice served as vice president and senior counsel at the Health Initiative, where she helped develop a privacy framework to govern health data not covered by HIPAA.
With CDT.
With CDT. So before we get into questions for the panel, I just want to remind folks, you can also ask questions. We're going to try to save some time at the end for questions. For folks in the room, you conveniently have a pen and a note card under your seat. If you feel inspired to ask a question, please just jot it down on the note card. My colleague Eric on the side here will help collect questions, and we'll at some point pass them up to me so we can ask the panel. For folks online, you're not left out. There's fun for you too. You can submit questions via an email. The email address is questions@cdt.org. Or if you're on Twitter, you can use hashtag CDT questions at our Twitter account, which is @SendDemTech. Okay, housekeeping aside, let's jump into some questions. So like so many panels up here, CDT filed comments on the proposed rule last year, and among the things that we called for were ensuring that reproductive health data was captured definitionally by the rule. There were real meaningful limits on the sharing of health data. There was strengthening the rules, the proposed rules attestation requirements, and then an education component that we actually talked to, and Alex and Director Fontes Rayner talked about earlier. So we're happy to see the final rule address some of these changes, and we know there's still more work to be done. Okay. So to the panel, and we can just, go down the road to start. I'd love to hear kind of folks' first initial reactions to the rule yourselves.
Sure. AMA supports the objectives of the rule. We see some challenges with the implementation, but physicians are strong supporters of patient privacy, and AMA welcomes the heightened protections around reproductive health care to protect patients and their physicians, who are often the ones caught in the middle when people with efforts to use people's sensitive health information against them or their medical provider. So we embrace the objectives of the goal, but there are challenges. It's going to be a significant implementation lift for physicians, 238 days from today. These systems need to be up and running. It's quite a lift, and we look forward to more guidance from OCR about the implementation strategies. And we want to make sure, especially rural providers and those with fewer resources, have what they need to launch this successfully. If you've ever done an implementation, the more you can get right the first time. Smoother it goes, the quicker you see the objectives that we all want to see happen with this rule.
Erin, top line.
Yeah, thank you. Thank you so much for having me. I think it's really exciting to be here today to shine a spotlight on these new protections. We applaud the administration action to expand protection for reproductive healthcare information in response to the chaos caused by Dobbs. We continue to see and to feel every day the ways in which that decision has undermined access to basic healthcare. And because we live in this information or data age, people are understandably increasingly worried about their privacy and whether and how that their information can be weaponized against them. And this is not an unfounded fear. Women have been subject to criminalization for pregnancy and abortion for a long time. Particularly Black women and women of color before this were more likely to be subject of investigations and proceedings related to lawful reproductive health care. And we also know that those communities of color are more likely to experience inequities in both access to and outcomes of care. So I think, we know that criminalizing pregnant people deepens mistrust and exacerbates these health inequities. And so this is a really important and exciting first step. And we are looking forward to working with the administration and all of our allies to continue the momentum.
Alice.
Thank you. And thanks also for having me. My top line take is going to be a little different because I don't work for an advocacy organization. I work for a law firm. So I think what my clients think. And yet I will say that in the wake of the Dobbs decision, Manat, the firm for which I work, formed a reproductive health working group where we've been really focused on what does this mean? What does Dobbs mean for our culture, but really more specifically, what does it mean for our clients? What does it mean for states? What does it mean for interaction with HIPAA and FTC rules, as we heard about a little bit? So I do think the clarity of this rule is enormously helpful. Whether or not it's the final word, probably it is not, but it is always very helpful when we get anything from OCR. This was such a privilege to be in the room with the director on how the agency sees this rule interacting with state law, how it sees the new rule interacting with other previous HIPAA updates, FTC updates. So we will be eagerly looking for further guidance, all of the videos, all of the implementation guidance, because the more that we hear from OCR, whether it's top line goals of the rule, why the rule was published. I thought that was very interesting to read in the preamble and hear in person. And then once we see how it's rolled out with respect to implementation, what we can do about addressing implementation challenges and concerns that arise.
Well, thank you, everybody. I think those are great first insights. Let's take a little deeper dive. Part of what Alex and Director Fontes-Rainer talked a lot about was that essential element of trust between a patient and a provider, and how privacy plays such an essential role in establishing that trust and maintaining that trust. So I'm going to start with Aaron and Lisa with this one. Let's talk a little more about how you guys see that new rule bolstering that essential trust between a patient and a provider.
Sure. Well, I'm happy to start. And I think given that the context is reproductive healthcare, it's important to have our history in mind. And the fact of the matter is that, again, Black women, women of color have long been subject to forced sterilization, to abusive gynecological practices, to a pattern of racism and mistreatment that continues today and is most starkly apparent in our maternal health crisis. And so there are communities for whom that trust with the healthcare system is, may have never existed. And so I think it's really important to have that in mind as you're thinking about whether and how this rule will bolster trust. So I think, again, this is a really important step. Again, and I think we'll talk a lot about this, how it will all come down to implementation and enforcement. Director Fontes-Rainer talked about, some of the requirements, the change to the notice of privacy practices. I think those are really important steps, and I think they have to be accompanied by ongoing conversations between providers and patients. That's really where those relationships are. That's where the trust is built. And so making sure that providers and patients understand their rights and their responsibilities under these new requirements is going to be important.
Yeah. So.
Yeah, I would say patients trust their physicians right now. They've lost faith in the system we use for sharing health information. In the current system, the same information, the same reproductive health care information that could land you in jail or cause your children to be taken away has the same level of privacy protection as your cholesterol number or your blood type. There are no tiers. It's all treated the same. And this new rule addresses that, so it can help to protect both patients and medical providers. And over time, with outreach and education, it can help to restore the trust that people have in the system to know that their lawfully obtained reproductive health care is truly private. It's not going to be shared with law enforcement or legal authorities unless they attest that it won't be used against the patient, the provider, or anyone who helped them or attempted to help them. That's very important for both the patients and providers.
No, absolutely. So Alice, let's turn to you for another question. Ray, we heard a lot earlier about how the Dobbs decision just kind of changed everything and kind of reset a lot and opened up a lot of new avenues where reproductive health information can be used in ways that just weren't possible prior to Dobbs. Why don't you talk a little bit about how this new rule seeks to kind of close some of those gaps? And also, you mentioned earlier, we've kind of seen how the states are reacting to this too. So if you could touch a little bit more about how states kind of on both sides of this have kind of approached the lead up to the rule and the rule itself.
Sure. one of the benefits that state level legislators have is that they can move much more quickly and be much more nimble than the federal government. The April 2023 proposed rule from OCR and then the April 2024 final rule, it's actually very fast moving. They responded very quickly. Dobbs is also several years old at this point. The states, on the other hand, in the wake of Dobbs, almost all of them reacted almost immediately. Some of those states took action that was now legal to restrict access to and provision of abortion, and others put into effect what we refer to as shield laws. As of a few months ago, it may have changed even since then because it changes so quickly. 15 states and the District of Columbia have passed what are called shield laws, which protect the rights of abortion seekers and providers in their own state, and specifically protect people who come even from out of state to receive or obtain lawful care within their state where abortion is legal. Some of those shield laws have come in the form of executive order, again, something that the state governors have the access to. Some of them have come in the form of updating the state codes and regulations themselves. But this HIPAA rule, when I was reading it, just made me think about abortion shield laws, because one of the central tenets of the state laws is to protect recipients or providers of lawful care in their state from out of state or from the disclosure of information from out of state investigations, imposition of liability, sort of extradition, all of these things that we were all worried about, given the patchwork of laws that we have in this state in the wake of Dobbs. The shield laws are really designed to protect those recipients of care in their state from those. The state shield laws also contain a number of protections for providers. They can't be subject to professional repercussions, whether that's in the form of licensure or malpractice insurance premiums. And some of them go so far as to protect actual residents from specific disclosure of identifiable information related to reproductive health or their identity of them in receiving that care. Some of them are broad and apply to gender affirming care and all reproductive health services. Some are a little more specific to abortion. All of that to say that this final rule is like those, but not as deep, not as nuanced, not as specific. They really take existing HIPAA permissions for disclosure and switch those to either having a prohibition for certain purposes, this purpose-based restriction, as we've been calling it, and a focus on presumption of lawfulness, which again, the states have access to because they know in their own states whether it's lawful or unlawful. That was a very long and boring answer to the question, but the point is that this is in line with state laws, but it doesn't go as far. So the sort of gaps that Lisa and Aaron are talking about, this law is not able to and does not accomplish that.
Understood. I didn't think it was that boring. Okay, so let's unpack a little more about take a next dive deeper into certain elements of the rules. And I think Alex and Director Fontes-Rainer talked about the presumption that the rule now instills that you just touched on a little bit more. But there's also an attestation component that an entity requesting this data now has to attest that it's not being used for prohibited purpose. I'll open this up to everybody, but feel free, whoever. Let's talk about kind of why that attestation is important, what elements are included within it, and why it's really necessary for this rule to function.
Sure. Yeah, it is an important component of the rule. And it sounds complicated. There are 6 required elements of a valid attestation. I think of it as 3, 2, 1, 3 names, 2 statements, and a signature. The name of the patient, the name of the discloser, the name of the recipient, a statement that it won't be used for a prohibited purpose, won't be used against the patient, the provider, or anyone who tried to help them access reproductive health care. This all pertains to lawful reproductive health care. Second statement, this is important too, that HIPAA penalties attach to anyone who seeks to abuse this process and also who would redisclose, and then the signature. So it's implementable. It will take, redesigned workflows. It was a scramble when HIPAA first came out everyone crafted a notice of privacy practices. Everybody crafted a business associate agreement. But we're happy to see some skin in the game, to put it that way, on both sides of the information sharing equation, because usually the penalties and the compliance obligations fall on the medical provider because they're the ones that are covered entities under HIPAA. But in this case, there are some significant penalties that attach. So we're pleased to see that. And with the presumption, I'll just quickly say, it sounds complicated and we don't want doctors to have to go through a difficult analysis. But if you think about it, the presumption applies to reproductive health care that was provided by someone else. So as they reviewed, you don't know, so you make a presumption or an assumption. When you're the one providing when you are the one who provided the health care that is in the records being sought, you don't have to make an assumption. You know what you did. So that clarifies, I think, a little bit for me, like it really makes sense to apply it to other providers, but not for the provider who provided the care.
Understood.
And I would say from the national partnerships perspective, I mean, as far as the attestation requirement goes, we had hoped for a stronger mechanism to guard against bad faith actors. We know they are out there, but we understand why the administration, why and how the administration finalized its requirements. And I think to Lisa's point about the difficulties of implementation, I also, sympathize with the concerns around administrative burden. And there are a lot of documentation requirements in healthcare, and especially when it comes to health information sharing. And we think that this rule strikes the appropriate balance for protecting people's information who are, seeking reproductive health care. And as we've discussed, it also provides that much needed clarity for providers. We have partners at Pregnancy Justice who have found that one of the leading drivers of criminalization regarding pregnancy status or outcomes is providers feeling pressured to report to law enforcement. And so we're hopeful that this rule will provide that clarity, that assurance that, they don't need to worry about that.
Alice, I don't know if you wanted to weigh in on.
I would only add in from the legal perspective, there's a lot of discussion in the final rule about how can a provider know when it is appropriate to rely on an attestation. And so that, to me, I was very appreciative from the provider client side of how much time and thought OCR went into this balancing test, as you say, understanding that it might be, that it is one more administrative layer of work upon them, but that they want to make sure that the providers feel comfortable in saying, I got an attestation and I'm going to rely on it, and I feel good about that. There's a culture of fear in a number of places in the healthcare system, not just on the patient side of obtaining care, which OCR also addressed in the rule, but of providers not knowing what they have to share, what they can't share, what they should be sharing. And so anytime there's specificity in what you should share under what circumstances and how you know whether or not the circumstances are appropriate, I think is much appreciated.
Excellent. Let's move on to kind of next steps now, right? You all represent different stakeholders, different entities within that provision of healthcare. We heard from OCR Director Fontes Rayner that, a big push from OCR moving forward is getting the word out about the rule. Why don't you talk about each of how your organizations are approaching that? What next steps you see for the immediate future and potentially longer off down the road?
Yeah, I would say this is when the work starts for physicians to get all these workflows up and running by late December. We definitely are looking for more specific guidance on aspects of the rule just to implement it, as seamlessly as possible. For example, what are the limits of requiring an attestation before you run afoul of the information blocking rules? There's been a lot for physicians to implement and adjust. There was, HIPAA, which is some time ago, and then more recently, HIPAA said, don't share patient information, but here are 6 scenarios where you can. Information blocking rules said, there's 6 scenarios. Instead of you can, you must, unless you fit another set of exceptions. And so layering this on top, it's going to take some intensive resources, education, and especially for our smaller and rural providers. So, we're looking forward to seeing more guidance on the specifics. And I'm sorry, our member channels, we have a lot. We put out an advocacy update every other week. Mailing goes out to the House of Medicine, to the state medical societies and the specialty organizations. We have a robust social media presence, and of course the AMA website.
Erin?
Yeah, I think I'll start by focusing a little on where we are eager to work with the administration and stakeholders going forward. Again, I think we fully understand and appreciate why the administration limited these protections to lawful reproductive health care. But the fact of the matter is that Dobbs and anti-abortion politicians are making all kinds of reproductive health care, from telemedicine abortion to emergency care for pregnant women, illegal or legally ambiguous. And it sort of just speaks to the confusion and the chaos that you were describing with this patchwork of laws, Alice. And so, we are concerned that there will be some significant portion of reproductive health care that falls outside of these protections. And those individuals not only need that care, but deserve to have their privacy protected as well. And so I think this speaks to some of the larger gaps in our health data and just data ecosystem that we need to fill. We talked, Director Fontes-Rainer talked about the limits of PHI, and we know, in addition to providing care protections for more care, we also need to protect more data. There is so much information that's either health specific, whether it's, pregnancy or menstrual tracking apps or location data that can be used to draw the same conclusions about the reproductive health care that an individual is accessing as PHI. And so we're really looking forward to, again, just working with everybody on strengthening privacy protections overall. I would say, in terms of the role that we play as advocates to get the word out about this rule, definitely working with a lot of our partner organizations, Planned Parenthood and others who have more direct contact with patients on the ground. But I think, to Lisa's point about the confusion and how, changes to HIPAA and how it will interact with information blocking, I think one of the biggest roles we can play is really just, again, shining the spotlight on this change, making sure that people are aware of it. I appreciate the desire to ensure and educate patients and consumers about their rights and responsibilities. As a patient advocate, when you are half naked in a paper gown, Director Fontes-Rainer talked about that imbalance that exists. And I want us to be mindful about how much we are putting on patients who are already navigating an incredibly difficult situation, a complex, turbulent political environment, to then put the onus on them to be reporting violations of their HIPAA rights. So, doing what we can to make sure that that isn't necessary in the first place.
And we at Manat volunteered to take on the job of explaining the Venn diagram of information blocking, interoperability, HIPAA, and FTC, and then, a subset of state laws. It is, I feel, job security, but it is complicated. And especially when you have laws like this new HIPAA rule, which say, here's when you can't or how you can't share information, and other regulations like information blocking that say, here's how you have to. It can be confusing. And so after you sign up for the OCR newsletter and the AMA newsletter and the National Partnership newsletter, Manat on Health does our best to synthesize that landscape.
Great. So before we pivot to questions, and for folks in the room and online, remember, submit questions if you have them. We're happy to answer them. Before we pivot to questions, would just love to go down one more time and kind of final thoughts before we pivot to questions, final reactions, takeaways.
I'd like to echo what Erin said about the biggest gap that I see is the health apps. Sometimes they're called health adjacent data. And again, everyone assumes my health information is protected by HIPAA, but these app developers, the app companies, they are not covered entities. They're untouched by HIPAA. There is no minimum standard for their privacy policy. And people don't know that. And the FTC has, I think, done a commendable job with the tools they have in recent years, but they usually can't step in until something really bad has happened. So I think some regulatory level setting in that space would be helpful. And, again, we look forward to working with OCR and our stakeholder partners to get the word out and to make this, we all want this to work. And for it to be workable, there needs to be clarity. Ambiguity is friction in the compliance context. So we need to get these workflows going and be in good communication about all the issues that need to be addressed.
Thank you. Yeah, I'm going to resist the urge to take us down the path of non-HIPAA covered health privacy. We could fill up a whole nother hour here, but I'm going to resist. So Alice, I know we could just break out the old.
Another plug for the consumer framework. But you know, to your point, Andy, there actually has been a lot of activity in the privacy space on the federal level recently. I know that there are many who think that there hasn't been enough. I know there are many who are still praying every single night for comprehensive federal privacy legislation. But when you think about what the FTC has done in the health app or non-HIPAA covered health data space in the last several years, and what HHS and OCR have done, and what CMS has done, there's actually been quite a lot of activity. And the administration really seems to be on it. Director Fontes-Sereno was saying earlier that there's some aspects of this that are nonpartisan, and that's absolutely true. Patient access to data and patient privacy are not, abortion of course is, and reproductive health is, but overall access to and privacy of data is not. And so I think we'll probably just see more and more, and we should be heartened that privacy is such a hot topic these days.
And I think I would just add, you know, the national partnership is ready and standing by to participate in the shared responsibility of implementation and education and awareness raising, because, you know, clearly there's a lot going on. There are a lot of people to inform, and so we look forward to assisting the administration and Manat and provider organizations and anybody else just to release guidance, to release maybe, you know, suggested ways, scripts to have conversations with patients, in addition to those sort of documentation requirements, we think will be very helpful.
Great. Okay, we've got a couple minutes for questions, so we'll just start. I'm not going to profess to know the answer to all of these, and I don't want to put anybody on the spot too as well, but let's give it a shot. So folks are asking if we expect the new rule to spark litigation, specifically from state AGs. As an addendum to that one, you know, what other ways do we think courts might play a role in this new rule? But I mean, we've already seen courts playing a role in this space more generally, but I mean, I think I'm not going to go on the list.
Yes.
Are there other ways that you see the courts getting involved besides just direct challenges to the rule?
I don't think they can get involved without direct challenges to the rule, but I think it's a matter of days, weeks before we start seeing those.
And I think that state attorney generals collectively already sued on the proposed rule. I mean, there's been it's a contentious space, as we all know. And I just want to say too, I expected to hear a little more about gender affirming care, because that was one of the things that AMA asked for that is being used, some would say weaponized, against patients and their care providers. And I thought it was well crafted. In the final rule, they have expanded the definition of reproductive health care. If you do a word search, there is not one instance of the word gender, but there's lots of encouragement to construe reproductive health care broadly. And if you look at the text of the definition, there's also a hint in footnote 163. So about marginalized communities. And I mean, that's who we are seeking to protect with this, vulnerable people. So that's very encouraging.
Yeah, I agree. That's one of the things that CDT called for in our comment as well, was the broad definition to include gender affirming care. So some more clarity on that is always welcome. I think we have time for one more. So again, I don't want to put Alice on the spot, but I'm going to throw this at you first. But folks are asking, how does the new rule interact with various state laws? Like, for instance, the Washington My Health, My Data Act.
I'm available for legal consultations at any point. I would just like to say, I'll answer it fairly broadly because the Washington My Health, My Data Act is very specific. But as everyone knows, federal law preempts state law, but also federal law is a floor, and states can layer on more restrictive policies and requirements on top of that. So if there is a state that would say that the uses and disclosures that the new rule prohibits are actually permissible, that would not fly anymore. But if the state wanted to impose additional protections or additional prohibited purposes or additional, for example, attestation requirements, expand the prohibitions in the new HIPAA rule, they would be able to do that. I can't off the top of my head think about what the permissions and restrictions in the Washington My Health, My Data Act are that might be either in concert with or in conflict with HIPAA. But I will say that there are more and more states are expanding their mini GDPRs, their state data privacy laws, to be specific to health data. We've seen it in Washington and several other states. And if you look at the map of where such legislation is proposed, it's almost all of them. So this task of analyzing the state health data specific privacy laws sort of outside their little mini HIPAA laws is going to just become more and more important. And the interaction with the HIPAA final rule will be a component of all of that state level analysis.
Great. I don't know if great. I think that is going to conclude our webinar and fireside chat today. I want to just take the opportunity to thank everybody. To our panelists, Lisa, Aaron, Alice, thank you so much for doing this, and not only doing this, but doing it on somewhat short notice. So thank you, thank you, thank you. I thought today's discussion was fantastic. A huge thank you to HHS, OCR, Director Fontes Rayner and her staff. Thank you to the CDT staff that helped put this together. And thanks for everybody for joining us and for participating. Yeah, I hope everybody has a great rest of your afternoon.